Ever wondered what it truly takes to become a lawyer, specifically an advocate, here in South Africa? It's far more than just acing exams. There's this whole intricate legal structure underpinning it all. Today, we're doing a deep dive into a really foundational piece of South African legal history. It's the Admission of Advocates Act 74 of 1964. This wasn't just some dry document. It was basically the blueprint for legal practice for, well, nearly 50 years.
Absolutely. And just so you know where we're getting our info, our source for this deep dive is an official consolidated version of the Act itself. We last checked it on August 1st, 2024, just to be sure, though the content itself was updated back on May 29th, 2015.
Right. So our mission really is to unpack this key act. We want to understand why it was created, look at its main parts, and really get a sense of the impact it had on lawyers and the legal world in SA for so long.
And it's super important to say this right at the start. While we're digging into this historical act, it's actually been repealed, gone, replaced by Section 119 of the Legal Practice Act, that's Act 28 of 2014, which came into effect on November 1st, 2018.
Okay, so it's not the current law.
No, not the current law. But, and this is crucial, understanding this 1964 Act, it gives you absolutely vital insight into the sort of foundational principles of what being an advocate means in South Africa. Think of it like studying the original blueprints of a famous building even after it's been renovated. You learn so much about its core structure, its design philosophy, and that stuff often still influences how it stands today.
That makes sense. A foundational look. So let's start right there at the foundation. What problem was this 1964 Act trying to fix? Its stated purpose seems pretty straightforward. To provide for the admission of persons to practice as advocates of the Supreme Court of South Africa and for matters incidental thereto.
Yeah, straightforward now maybe, but you have to picture what came before. It was, well, a bit of a mess, frankly. Imagine trying to figure out the rules when they were scattered all over the place.
How so?
Before 1964, the rules for becoming an advocate were fragmented. They were stuck in various old laws, ordinances, different rules for different provinces. If you look at the Act's schedule, the list of laws it repealed, it's huge. You've got the old Cape Charter of Justice and 1858 Cape Act, Natal's Supreme Court Act from 1896, the Transvaal's Administration of Justice Proclamation from 1902, even Republic Acts like the 1921 Admission of Advocates Act.
Wow. Okay. That does sound complicated.
Exactly. So this 1964 Act was a massive step. It aimed to consolidate all that, to standardize the rules across the entire republic, create one unified system. It wasn't just tidying up, it was about building a truly national legal profession, making justice more accessible, streamlining things for advocates wanting to practice across provincial lines. It cut down so much admin and aimed for a consistent standard.
Right. A huge standardization effort then. And this whole new system kicked off on a specific date.
It did. February 18th, 1966. That was the official commencement date, the day the unified system formally began.
Okay, so the act's in place from 66.
Yeah.
What did it actually demand from someone who wanted to become an advocate? What were the main hurdles?
Well, first off, Section 2 made it crystal clear. It basically said, this is the only way in. No person could be admitted except according to this act, period.
No loopholes.
Pretty much. Then Section 3, Subsection 1 laid out the fundamental criteria. First, you had to be over 21. Simple enough.
Okay.
Second, and this is a big one, still absolutely central today, you had to be a fit and proper person to be so admitted and authorized.
The fit and proper test. That sounds important, but maybe a bit subjective.
Hugely important, and yes, inherently subjective. It's the bedrock of trust, really. It means more than just being academically qualified. It speaks to integrity, honesty, your whole character, and suitability to uphold justice. Historically, it's been vital for protecting the public, but sure, its application could sometimes reflect the social views of the time. It's a powerful reminder that law is about people and character, not just rules on paper.
Makes sense. What else was in that Section 3.1?
You also needed to be a South African citizen or lawfully admitted for permanent residence and ordinarily living here. And finally, if you happen to have been an attorney before, your name had to be officially removed from the roll of attorneys, and it had to be at your own request.
So you couldn't be both an attorney and an advocate at the same time under this system?
Not without that clear break, no. It reinforced that traditional separation, advocates focusing on court work and opinions, attorneys handling clients more directly. That distinction was seen as crucial for specialization and, avoiding potential conflicts back then.
Right. Okay, so age, character, citizenship, not being an attorney simultaneously. But the big one must have been the qualifications, being duly qualified. What did that involve educationally? Must have been tough.
Oh yeah, definitely rigorous. Section 3, subsection 2 spelled it out, the main route. You needed to have satisfied all the requirements for an LLB degree, that's the Baccalaureus Legum from a South African university. And critically, it had to involve at least 4 years of study.
4 years minimum for the LLB. What if you had another degree first?
The Act allowed for that too, which was quite forward-thinking. If you already had a different bachelor's degree, you could then do an LLB. But the combined study period for both degrees had to be at least 5 years total.
Okay, so 5 years if you combine degrees. What about degrees from outside South Africa?
Also covered. Section
cool.
3 dealt with that. You could potentially use a degree from university in a country that the minister, after chatting with the General Counsel of the Bar, had officially designated.
Designated.
Yeah, basically approved. But there was a catch. A South African university's law faculty had to look at that foreign degree and certify that its syllabus and standard were, and I quote, not lower than that required for a SA LLB or even superior. So it had to be equivalent or better.
High bar then.
Definitely. And the Act was also careful about the transition. It included provisions, sections 3 through E, that essentially deemed certain people to be qualified. This covered those who met the old provincial criteria before the Act or who were already registered law students when the Act kicked in. It shows they were trying not to, pull the rug out from under people already on their path.
That seems fair, managing the changeover. But what about advocates who were already practicing when the Act came into force in 1966? Did they have to reapply or something?
Good question. No, the Act was smart about that. Section 4 handled existing advocates. It basically said anyone whose name was already on the roll of advocates in any division when the Act started was automatically deemed to have been unconditionally admitted under this new Act.
So they were grandfathered in, essentially.
Exactly. It ensured continuity, preserved their status, avoided chaos, kept the system stable.
Okay. So once you were admitted under this new, shiny, unified 1964 Act, where could you actually practice law? Was it still limited by province?
No, and this was a huge change. Section 6 was key here. It stated clearly that any person admitted under this act was entitled to practice as an advocate throughout the Republic.
Throughout the whole Republic?
The whole Republic. That really cemented the national nature of the profession. No more being admitted in, say, the Cape and needing separate permission to appear in the Transvaal. An advocate was an advocate countrywide. Imagine the difference that made.
Yeah, a massive practical difference. Now, you mentioned foreign degrees earlier. What about advocates already qualified and practicing in other countries? Could they come and practice in South Africa under this act?
There was a specific path for that, outlined in Section 5. Admission to practice in the Republic of Advocates practicing elsewhere. But it wasn't automatic. First, they needed to be admitted to practice in a Supreme or High Court in what the Act called a designated country or territory.
Designated again, so approved countries only.
Yes, designated by the minister, again, after consulting the General Counsel of the Bar, and published in the Government Gazette. Plus, they had to actually reside and practice primarily in that designated country. They couldn't just hold the qualification.
Okay.
And importantly, they still had to satisfy the South African court that they were a fit and proper person, just like local applicants, and that no disciplinary proceedings were pending against them back home. Oh, and the minister could also withdraw a country's designation later on, so it was a controlled process.
Right, controlled access.
Yeah.
Now, once you're in, you're practicing. Maintaining standards is obviously crucial in law. What did the Act say about discipline? What happened if an advocate, fell short? Or if their circumstances changed, like citizenship?
The Act tackled this head-on in Section 7, covering suspension of advocates from practice and the removal of their names from the role of advocates. There were several grounds.
Such as?
Well, for instance, if you ceased to be a South African citizen, or if you were admitted as a non-citizen needing to naturalize and you failed to do so within the required 6 years. For those foreign advocates admitted under Section 5, if they stopped living or practicing in their home country, or if that country lost its designated status, that could be grounds.
Okay, those seem fairly administrative or status-based. What about conduct?
Yes. The big one, mirroring the admission requirement. The court could suspend or strike someone off if it was satisfied that he is not a fit and proper person to continue to practice as an advocate. That's the ultimate safeguard for professional integrity.
And could an advocate just quit?
Yes. They could also apply to have their own name removed from the role, perhaps if they were retiring or moving into a different field entirely.
So who could actually initiate these disciplinary actions, the striking off or suspension?
That's interesting, as it points to the self-regulating nature of the profession. The act specified that applications could be brought by the General Council of the Bar of South Africa, the national body, or a specific provincial bar council, or the Society of Advocates for the relevant court division. These are the advocates' own professional bodies.
So the profession policing itself, essentially.
Exactly. It underscores the independence of the bar.
What about senior counsel status? The SCs or silks. Could that be taken away?
Section 8A addressed that. It gave the state president the power to withdraw an appointment as senior counsel, but specifically if the person requested it, and particularly if they'd been appointed SC while working for the state. It allowed them to revert back to just being an advocate, maybe if they left state service for private practice.
Okay, so a mechanism for reverting status. With all these admissions, suspensions, removals, how is everything kept track of officially?
Good question. Section 8 mandated a central role of advocates. This official register was kept by the Director General, Justice. It listed everyone admitted, the details of their admission court order, and, critically, any subsequent orders for suspension or removal.
A central database, basically.
Pretty much. And a certificate issued by the Director General confirming someone's status on the roll or their suspension or removal was considered prima facie proof accepted as correct unless challenged. Made verification much simpler.
Now, shifting gears slightly to protecting the profession itself, what about people pretending to be advocates or advocates engaging in, say, dodgy financial dealings? Were there specific offenses?
Oh, yes. Section 9 laid out clear offenses.
Yeah.
First, it flat out prohibited anyone who wasn't properly admitted and on the roll, or someone who'd been suspended or struck off from practicing, or even just holding themselves out as an advocate. You couldn't pretend.
Makes sense. Protects the public.
Absolutely. Second, and this was really fundamental to the structure of the bar, advocates were forbidden from sharing their professional fees with anyone except another practicing advocate.
No kickbacks to attorneys or anyone else.
Precisely. It reinforced the advocate's independence, ensuring their loyalty was to the client and the court, not tied up in financial arrangements with, say, the attorney who briefed them. It maintained that distinct role.
What were the penalties if you broke these rules?
They weren't insignificant for the time. Contraventions could lead to a fine not exceeding 200 Rand, which sounds tiny now, but you have to remember the value of money in the 60s, or imprisonment up to 12 months, or potentially both.
Right. Context is key for the money value.
Definitely. And crucially, for an advocate caught sharing fees improperly, that wasn't just a fine, it was also deemed professional misconduct, which could lead straight back to Section 7 suspension or being struck off the roll entirely. Serious stuff.
So the rules were strict. Only admitted advocates could practice, and they couldn't share fees. Were there any exceptions? What if you were in a tiny town and the only advocate was unavailable or unwilling to take your case?
The Act actually had a practical solution for that. Section 10 provided a specific exception. It gave the court the power to permit attorneys to discharge functions of advocates in particular proceedings.
Ah, so an attorney could step in.
Yes, but only in specific proceedings before that court, and crucially, only if there is no advocate available or willing to act. It wasn't a free-for-all, it was a safety net, a pragmatic way to ensure access to justice wasn't completely blocked if an advocate simply couldn't be found or wouldn't take the case.
A practical safeguard. Okay, so we've walked through the core of this 1964 Act, bringing it back to today. What does all this mean for you, the learner, listening now? This Act isn't even in force anymore. Why dig into it?
Well, even though it's repealed, its legacy is undeniable. This act created the modern structure for the advocate's profession in South Africa, a structure that lasted almost half a century and heavily influenced the system we have now under the Legal Practice Act. It defined the pathway, the standards, the very identity of advocates for generations.
So understanding this history helps understand the present.
Absolutely. Connecting it to the bigger picture, this 1964 Act was the bedrock. It took that fragmented, messy system and unified it. It set clear national standards for who could become an advocate and how they should conduct themselves. Its eventual repeal in 2014 by the Legal Practice Act simply marks the next stage in the evolution of regulating lawyers in SA, often pushing towards more integration or different oversight models. But you can't fully grasp where the legal profession is now without seeing the powerful foundations laid by this historical act.
That definitely puts it in perspective.
Yeah.
Which leads to a final thought, something for you listening to perhaps mull over. How do the underlying principles and requirements, we've talked about things like the fit and proper person test, the educational standards, the rules around independence, How do those ideas embedded in a historical act like this continue to resonate and influence the legal profession today, even under completely new legislation?
Yeah, what fundamental aspects of legal professionalism do you think truly remain constant, timeless almost, regardless of the specific law on the books at any given moment? It's something worth considering.
Indeed. A great question to ponder.
Well, thank you for joining us on this deep dive into a really foundational piece of South African legal history.
Keep digging, keep learning.